Hi everyone. So we got through what ended up being a 9-part video on the Rule 56.1 document from Lively. Now we are dealing with the replies from Wayfarer to Lively and Jonesworks for the summary judgments, the reply to Lively for the judgment on the pleadings, and then we will have Rule 56.1 replies then for both Jonesworks and Lively, which I will deal with in further videos. Okay, so let's start. So this is Wayfarer's reply to Lively's opposition for motion for summary judgment. Now it's 38 pages, which is substantially shorter than the actual motion and the opposition. I'm going to try and do it all in one go because obviously, we've got through how many pages already? Like I think 7 pages in, 8 pages, and it's only now just starting. So, okay, we can deal with this. My voice is struggling a little bit. I spent 8 hours recording yesterday, and I think I'm just having a little bit of a moment, a wobble with my voice again. Okay. Now, I haven't read this. I've heard it is amazing. It is very, very spicy. So I'm looking forward to it. Sorry, I'm just trying to get this right. Why is it doing this? Okay. Yeah, I've heard that this is actually really quite spicy and a good clapback. So let's go. Lively spills lots of ink. I love it already. Attempting to conjure up factual disputes, but the material facts are undisputed. Her opposition and 56.1 response confirm she has launched a massive legal campaign to address minor grievances. Do you know, I think that's really fair. I think that shows a little bit of there's a bit of honesty about, well, yes, there were niggles, there were little problems, but it was nothing that warranted all of this. And I think that would be appreciated. It'd be like Johnny Depp, not trying to pretend he didn't have an alcohol and drug problem, whereas Amber Heard did. He owned his faults, and that worked really well for him. Because if someone's prepared to lie about something, that is, well known, then what else are they prepared to lie about? Amber Heard flatly denied a drink and drug problem, despite overwhelming evidence, including from people who knew her, professionally or otherwise, saying that she had a problem. So I like this. I like the fact that they are kind of starting out by saying, look, we had some problems. They were small little grievances, petty little things, and they were dealt with at the time. We believe they were dealt with at the time. She is saying, oh, actually, I'm changed my mind. They weren't. And, just basically hit the nuclear button, which is totally unnecessary. Even Judge Lyman might agree with that. Let's continue. Her opposition, yeah, I'm going to say that again, actually. Her opposition and 56.1 response confirm that she has launched a massive legal campaign to address minor grievances, all of which were resolved during production of the film without the need for any litigation at all. She recites a litany of supposed harassment ranging from yelling to defensiveness, to a conversation Lively herself initiated about redacted, to an incident she assured at the time was a non-event, but cannot say any continued after she asked for them to stop. They did stop, and then the parties worked together to produce a successful film, not only bringing her not only riches, but an extraordinary set of professional accomplishments. She touted to the Producers Guild of America as a rare achievement as a woman. Oh, did she? Oh, it's a rare achievement. For what? For women to pick out clothes? Not satisfied, she now claims discrimination, arguing, among other things, that her bespoke, heavily negotiated contract was violated, even though she never signed it, and that despite her near total control over the production, she was merely an employee. She also claims defendants unfairly resorted to professional PR firms for guidance, even while she and her husband openly badmouthed Baldoni and ginned up a flurry of negative press about him. She alleges a smear campaign but fails to point to a single falsehood any defendant uttered against her. Lively's claims do not meet the requisite standards. Summary judgment should be granted. Argument. I love how big the font is here for the subheadings. Lively cannot prove any actionable sexual harassment. Nothing in Lively's opposition overcomes the clear reality that she alleges low-level behaviour, trivial grievances, and petty slights. Redacted yelling and the other assorted conduct she alleges may be bothersome, but they do not rise to the level of a discriminatory, hostile work environment. Lively apparently recognizes Baldoni's conduct doesn't get her there. It boils down to a comment about Redacted after she raised the topic and before she agreed to work on the movie. So that Redacted bit would be about circumcision. I don't even know why it's redacted. We know. After she agreed to work, before she agreed to work on the movie, discussions about sex and sexiness while collaborating about how to depict an intimate relationship and sex scenes, and a remark about her weight made Offset to a person uninvolved in the film. She thus now attempts to make Heath the poster boy of sexual harassment. Based on what? A brief glance in an already awkward situation, after which Lively undisputedly told Heath, "I'm not saying you were trying to copperlook." Heath showing her a video related to his child's birth, shared in the context of producing a film with a prominent childbirth scene. When it is undisputed, Heath showed the same or similar image to Baldoni and to Redacted, that would be Ange Giannetti, who found it wholly inoffensive. It is remarkable that after months of discovery, Lively cannot muster anything more to justify the tremendous legal and judicial resources devoted to this case. It is even more remarkable because whatever concerns she were fully resolved once she raised them. Even Lively does not meaningfully dispute that the entire second phase of filming, including all intimate scenes involving Lively, occurred without incident. That's true. Okay, 1. Lively cannot establish the conduct at issue was aimed at her or anyone else because of gender, which is very important. A basic prerequisite for sexual discrimination claim. And I pointed this out, I think it might have been in my part 9 of the 56.1. There is a statement in there from Lively, something, a statement that she has listed as undisputed, where she makes the comment that, I can't remember if it was Wayfarer or Baldoni and Heath or Baldoni on his own, made people, women, made women, and then next to it was in brackets, and some men uncomfortable. And I made the point, Well, how can you then say that it's because of your gender when you are literally putting in brackets and some men? It's not a gender thing then, is it? It's a clash of personalities. You don't like his personality. Okay. She concedes the alleged conduct affected women and some men. Oh, they've actually quoted. Oh, there we go then. They've actually quoted that. And some men. Yeah. Sorry, I usually stop to comment on something and then I haven't read the next sentence. She abandons various allegations such as improper hugging because she cannot dispute that both men and women were hugged. Lively's own evidence further undermines her claims. It confirms Baldoni's stated motivation in privately inquiring about her weight was not to demean her as a woman, but to anticipate his own physical obligations. Redacted. Lively's trainer's opinion redacted. Is neither in it. Lively's trainer's opinion redacted is neither admissible nor competent evidence on summary judgment, nor does Lively dispute that she herself repeatedly raised concerns about redacted. Lively continues to complain that Baldoni once complimented her personal outfit and later the same day referred to her wardrobe as sexy. Lively strains to suggest her costume was revealing, but cannot dispute video footage showing it was, in fact, an oversized fleece onesie. Nor can she show this was a gendered attack. Lively notes Baldoni similarly referenced to a male actor as redacted, while Lively herself joked about redacted, another male actor to market the film. Proclaimed that redacted and insisted upon the redacted of her character's wardrobe on more than one occasion. Sexiness was indisputably used at times to describe a film devoted to adult themes, not invoked to pit one gender against another. Lively also complains that Baldoni improvised physical intimacy. Lively adduces no evidence to suggest he did this to offend her based on gender. Baldoni was not targeting Lively as a woman. He was in character, filming a scene in which, as Lively puts it, his character and Lively's were redacted. Such conduct would not be acceptable in a typical office setting, but in the context of two professional actors making a romantic, sexually charged movie, it cannot constitute discrimination. Lively's own declaration describes other kissing scenes in the film as vital to conveying the redacted. Her complaint that Baldoni added intimate scenes fails for the same reasons. Lively does not dispute that she too revised the script to increase the redacted. Any gendered animus is further undermined by undisputed facts that Lively was invited to discuss her views about the intimate scenes with a female intimacy coordinator before filming and proposed revisions. Lively's effort to evade this conclusion by characterizing the film's birth scene as unscripted nudity is absurd. She claims she was unexpectedly required to imply nudity, redacted, under a hospital gown and prosthetic belly. Oh, I made this next point myself. I made this point myself. But Lively, a mother of four, must have known people generally don't wear pants to give birth. And that's what I said this yesterday. I said it a few days ago as well, in one of the earlier parts. People don't give birth wearing underwear. Even if they have a cesarean section, you don't do it wearing underwear. So also she also, admitted as well on this point that she did actually wear a hospital gown and prosthetic belly. She originally implied that she was a lot more nuder than that she was only wearing what is called a modesty patch, a very thin piece of fabric that covers genitals. It's literally glued to an actress's genitals for nude scenes, basically. Um, there is absolutely no rhyme or reason why this would be needed in this kind of scene. And it did not fit. It did not make me, it made no sense whatsoever. So I could understand like the side of the leg needing to look like it is like needing to look like she's not wearing underwear, because it would make no sense if she was sat there filmed in what is, clearly wearing underwear, because people don't give birth wearing pants. But no one was looking front on at her. So therefore, no one needed to see her actual genitals, which she's claiming she had to cover with a modesty patch. And even if that was the case, wearing the modesty patch is a film industry. It's well known. It is a practice that is common in the film industry. It is not sexual harassment. This is not a new thing that Wayfarer cooked up in their minds that only Lively has ever been subjected to. It's so stupid. Okay. Nor were comments Baldoni supposedly made to Lively about his personal experiences gendered. It is undisputed that any such comments were substantially similar to statements Baldoni has made in talks and books aimed primarily at male audiences. Lively also notably does not dispute that she shared her own views about intimacy with Baldoni during Redacted about the film. 2. Nor do the two alleged incidents involving Heath provide any evidence of gender discriminatory animus. Lively cannot dispute that 3 witnesses testified Baldoni asked Heath to show Lively the birth video for non-gender based reasons, following discussions about the birth scene in the film. Indeed, she admits Baldoni contemporaneously told her Redacted. After Lively objected, no one persisted in showing her the video. It is undisputed that Heath also showed the video to Baldoni, a male participant in the film. Similarly, Lively admits Heath entered her trailer once, not for any gender-related purpose, but to discuss Redacted, with her permission. Lively asked Heath to turn away from her, and undisputably he did, and that was confirmed by Alex Sachs in her deposition. That, she did actually agree for him to enter the trailer on condition he turned away, which he did. She claims that at some point he glanced at her anyway, but doesn't dispute later assuring him, "I'm not saying you were trying to cop a look." She cites no evidence supporting her claim that she raised the incident with Heath Redacted, nor is there any evidence she raised it during the call with the Sony executive a few days later when she redacted about the production. And while harassing conduct need not be motivated by sexual desire, Lively admits that the very sentence she cites for that proposition underscores that the conduct must be motivated by gender. She cannot make that showing here. Lively depends her reliance on limited, sporadic, one-off instances of alleged misconduct by citing one case in which a single incident sufficed. Bailey versus San Francisco District Attorney's Office. In reaching that conclusion, the court was clear that isolated incidents must be extremely serious to give rise to an actionable claim. Unlike here, the incident in Bailey involved an unambiguous racial epithet, the N-word slur. The N-word, a slur so universally recognized that its discriminatory intent cannot be denied. 3. Beyond Heath's conduct, Lively does not even claim anything she personally experienced was sufficiently severe or pervasive to prove harassment. She largely ignores significant authority, confirming her allegations are too mild. She dodges the undisputed critical fact that any alleged harassment ceased once she raised concerns. No issue arose and no incident recurred throughout the remainder of filming. And that was not just defendant's view. It is undisputed that redacted. Sachs testifying that the set was redacted. How could the conduct be severe or pervasive if it vanished once the issue was raised? So much so that Lively, advised by counsel, concluded no formal HR process was warranted. Even the authorities' Lively claims support a relaxed standard require proof of severe or pervasive conduct for a hostile work environment claim. For example, Bailey confirms that simple teasing or offhand comments and isolated incidents, unless extremely serious, are not sufficient to create an actionable claim of harassment. Lively relies repeatedly on California Governing Code 12923, a 2019 proclamation from the California state legislature declaring its intent that summary judgment is rarely appropriate in harassment cases. That proclamation has no bearing on Lively's Title VII claims and, by its terms, merely states a legislative view. California courts have also confirmed that it does not mark a substantive change in California law. Indeed, federal courts in California continue to grant summary judgment in FIHA cases where severity is not shown. 4. Lively tries to bolster her claim by invoking the alleged experience of other women. Okay. There is no evidence Lively knew about most of these alleged events prior to litigation, even if they occurred. Several of these alleged events are supported only by rank hearsay and other inadmissible evidence. Such unsupported claims must not be considered. Moreover, the conduct she discusses adds little weight to her claims. Like Lively, co-star Jenny Slate refers to a single instance in which Baldoni referred to her wardrobe, which included black leather pants, as sexy, a term which, as noted, was widely used on set, including by Lively herself. A one-off remark may be unwelcome, but it is not so severe or pervasive as to give rise to a claim. It is undisputed that Baldoni acknowledged Slate's concerns, redacted. Lively also claims Baldoni yelled at female producer Alex Sachs. Yelling without more is not evidence of gender bias, even if Sachs resists such an interpretation, noting that Baldoni treated men similarly. And then they've quoted, defendants have a way of making women and some men feel like shit. Lively's references to verbal abuse supposedly experienced by another director on another set of a different film have nothing to do with the work environment at issue in this case. In any event, the alleged verbal abuse is only vaguely described with no suggestion it was either sexual or gender-based. Likewise, the claim that author Colleen Hoover was not involved in the script and did not receive dailies has no evident connection to Hoover's gender or to the on-the-set environment. Finally, Lively criticizes Baldoni, redacted. There is no evidence it was gender-based. Because, as is now undisputed, all the issues Lively raised were resolved, she cannot show that the conditions of her employment changed. This is yet another reason to dismiss her claims. Lively argues that even though she voiced no objections during the second phase of filming or thereafter, defendants' huffy and defensive reactions to Lively's behavior were themselves harassment. But the two occasions in which Lively claims that occurred were both during the first phase of filming. Regardless, the law is clear that such minimally unfriendly conduct does not amount to the change in the terms and conditions of employment, required to prove a hostile work environment. On the contrary, the Supreme Court has repeatedly stated that the standards for judging hostility are sufficiently demanding to ensure that Title VII does not become a general civility code. Okay, Lively cannot prove any actionable retaliation. Perhaps aware of the shortcomings of her argument, Lively insists very little evidence is required. What she has is not enough to save her retaliation or aiding and abetting claims. Lively's claims that she has made out of a prima facie case fails on multiple grounds, and even if she has, defendants have presented a clear, non-pretextual justification for their publicity efforts, which were a reaction to a media firestorm and not to any complaint by Lively months before. Okay. Lively did not experience any adverse employment action. It is now beyond dispute that no material aspect of Lively's employment changed for the worse. Her compensation did not decrease. Her role was not diminished. That alone is enough to defeat her claims. Lively tries to evade the point by expanding her supposed employment to include post-filming activity as well as her campaign to get a PGA mark. But Lively was not hired as an editor, director, or producer. That she had any role in post-filming activity is proof that her responsibilities expanded, not contracted. And that is such a great point. That is a fantastic argument to make because she was hired as an actress. She did get an executive producer credit, but that was just a title that is given to, kind of the bigger names or big contributors. Colleen Hoover also had it. So it's just a ceremonial title. It means nothing. It requires nothing, and it promises nothing. In any event, it is undisputed that Lively did get the opportunities and references she saw, including defendants' endorsement of her PGA mark. She described her accomplishments, redacted, and not as any setback. Lively's complaints that she was made to feel guilty and was criticized to Hoover and others are minor or relatively trivial adverse actions that, from an objective perspective, are reasonably likely to do no more than anger or upset an employee and are not actionable. Any such conduct had no material effect. The record is replete with evidence that after May 6, 2024 dinner, about which Lively complains, Hoover worked closely with Lively, redacted. In lieu of any material harm, Lively relies on the CRA to argue that mere changes in attitude or sarcasm could be enough. Yet, precisely because there is no material harm, no damages can arise from any alleged contractual breach, even assuming the CRA was a binding agreement, which it was not. There's a footnote here. Lively distorts the record by suggesting she was entitled to a producer credit rather than the ceremonial executive producer title in the offer letter. Lively admits she first undertook to edit the film without a promise of a producer credit. Indeed, she was not granted a producer title until June 2024. Lively stated she was redacted. Defendants' publicity efforts were reasonable defensive measures that are not actionable as retaliation. Lively cannot meaningfully dispute that defendants' publicity efforts took place outside the workplace in the arena of public opinion. Undisputed facts show Lively chose that arena and exercised immense power within it. It was Lively who unfollowed Baldoni, tantalizing social media sleuths. It was Lively who disparaged Baldoni to her famous friends. Documentary evidence shows Lively's husband redacted, I want to know what that is, while Lively redacted, causing a media furor. Just days after the premiere, redacted. Lively's opposition fails to identify a single factually false statement defendants shared or promoted in response to this onslaught. And again, I said this as well. I think it might have been in the finale, um, or video 8, but definitely, like they were reading off statements such as, you know, the contents, the slow dance, showed that what Lively had put in her complaint was not true. And she was like, well, that's not fair, and she was sort of citing that people talking about it, people like me talking about that was evidence of a smear campaign. But the timing that the media were talking about these events was when Wayfarer filed its complaint and subsequent first amended complaint with the Exhibit A timeline. There was nothing that actually pointed to Wayfarer were giving this stuff to the media, but that's not what Lively was saying. And even if they were, it was already publicly available in legal filings. But she was saying, well, this is a smear campaign. They were smearing me. But the thing is, right, is the stuff that they were reporting on was stuff that there was actually evidence of. It was Wayfarer's evidence, such as the dragon's text. Like she tried to say that was part of the smear campaign. Oh, they were talking about it. They leaked the text message to the media. It was literally what she said. But no, it was in the filings. We all read that. We all laughed at it. She claims multiple incidents placed Lively in false light, but fails to say which ones or how. And yeah, how? They were your text messages. She complains defendants exposed her to criticism for past conduct, but does not dispute those criticisms were already in the public domain before any publicity by defendants. Lively faults defendants for supposedly contending she weaponized feminism and took the movie over, but it is undisputed that Lively claimed to have redacted. She also claimed that redacted, clearly invoking a feminist theme. Lively asserts that she was unfairly criticized for shifting the film's marketing strategy away from domestic violence. No, there's nothing unfair about that. Yet it is undisputed that the film was always intended to raise awareness about domestic violence and that Lively redacted. In claiming Heath admitted her marketing was redacted, Lively misrepresents. In the very document she cites, Heath expressed concern to Sony about how many people are pointing out that the DB is being glossed over and encouraged everyone to be more deliberate in embracing the DB aspect. And that's exactly right. She is saying, well, the marketing was fine. I did great with the marketing. What are you talking about? Well, the world is sitting there going, we don't like marketing. You're glossing over the DB aspect. The other thing as well, it dawned on me last night when I was talking to House of Chair on our live stream, but in the same month, right, Lively is actually complaining on the one hand that she's upset because, Baldoni had to have a couple of hours chat to tell her how awful her wardrobe choices are. So much so that, he was crying in her trailer, right? So she makes that point, right? That he is explaining to her that her wardrobe choices are awful. And then later on, like literally a couple of weeks, if that, maybe days later, in the same month, right? So just a couple of days later, so the start of filming, which I think is the 15th of May, right? Baldoni's telling Lively in her trailer, no one likes your wardrobe, it sucks, right? He's passing on Sony's message. I'm paraphrasing, he's not literally saying it like that, but that's part of the complaint. And then less than a week later, he's calling her wardrobe sexy. I mean, we're supposed to find that believable. I don't. I don't. I think it's exactly right. It's where he's, I've said it before. I think Baldoni is neurodivergent. I think he's mirroring language. She is it said, I'm going, sexy. I'm looking for sexy. He keeps referring to things as sexy, and he's just mirroring that. But the two things cannot be true. How can he both think her wardrobe sucks, but also think her wardrobe's sexy and, is ogling her because of it? It makes no sense, especially when those statements are supposedly only a week apart. Anyway, we continue. Okay. Regardless, it is undisputed that Lively was criticised not simply for de-emphasizing domestic violence, but for simultaneously promoting her other projects and those of her husband as well. The record is clear. Such criticisms appeared in the press independent of any effort by defendants. Lively cannot prove causation. Lively engaged in no protected activities after her protection's demand. Lively tries to shrink the temporal gap by stretching out her claimed protected activities. That doesn't work because Lively has never claimed any of the additional events she now relies upon, such as redacted or refusing to promote the film with Baldoni as activity intended to oppose discrimination, and there is no evidence any defendant understood them as such. Elsewhere, Lively describes the redacted as immaterial, and her cited evidence doesn't refer to redacted she now relies upon at all. An action cannot constitute protected activity where there is no evidence the employer knew that the employee's opposition was based upon a reasonable belief that the employer was engaging in discrimination. And even assuming such conduct could constitute protected activity, it is undisputed defendants respected Lively's request. Baldoni did not insist on promoting the film with her. And then something is redacted, a provision Lively never invoked. Lively lacks direct evidence of retaliatory animus. Lively next asserts the temporal gap between her objections and the publicity campaign doesn't matter because she can show a direct causal link. But conspicuously lacking from the record is a single piece of evidence in which defendants say they are initiating a publicity campaign to get back at her for raising objections on set. Instead, she relies on messages in which defendants express concerns about her possible prospective activity and seek to prepare for the fallout. Those cannot prove a retaliatory motive, and it is undisputed that defendants' conduct consistently resulted in Lively's gaining more power over the production, not less. Yeah, really good arguments. Undisputed evidence proves defendants' non-retaliatory motives. Lively argues no admissible evidence shows defendants had a legitimate non-discriminatory motivation. She is wrong. Undisputed facts show that when defendants decided to engage a crisis PR team, they did so to protect their own reputations and that of the film against an anticipated onslaught of negative publicity, not to retaliate against her. Indeed, Lively admits defendants first met with TAG only on July 25th, after negative publicity had already begun. Don't forget, the negative publicity actually started with the mere announcement that Blake Lively was going to play Lily Bloom. People did not like it, did not think she was a good fit, thought she was too old, and did not think that she had the sensitivity to handle a theme like domestic violence. And they were right on all counts. Lively lacks evidence to show, as she must, that her purportedly protected activity was the but-for cause of defendants' conduct. She cannot possibly meet that burden on this record, nor can Lively credibly argue that defendants welcomed the media fracas as a pretext to attack her for her objections. Just quickly, the Footnote: Lively's case law about legal buzzwords is inapposite. Her cases concern circumstances in which a layperson used the wrong words to make a complaint, whereas Lively was well resourced, assisted by counsel, and knew how to make her concerns known. Rather undisputed evidence, including materials Lively cites, shows that defendants were terrified and doing everything they could to avoid a confrontation. Post-litigation conduct cannot save Lively's claims. Lively leans heavily on actions defendants and their counsel supposedly took after she filed her CRD complaint. But if Lively did not suffer any actionable retaliation before commencing litigation, she should not be able to create a claim based on post-litigation conduct. Any such conduct by defendants would be a response to the litigation she commenced, not a response to any workplace complaint about harassment from many months before. Lively was an independent contractor, not an employee. Lively attempts to paint herself as a mere employee. In doing so, she ignores her own extensive admissions, including redacted. She also ignores the highly bespoke contracts she negotiated, including an agreement that the production's location be moved closer to her own home, rights over many aspects of production, and a rider insisting on her own unilaterally imposed terms as a condition for going forward. If, as she argues, control is the determinative factor in determining whether a traditional employer-employee relationship exists, it is difficult to imagine anyone having more control. That's a great argument. The circumstances bear no resemblance to those in Makarova against the United States, the only authority upon which Lively relies. There, the Second Circuit emphasized that the Kennedy Center consistently maintained full artistic control over not only a ballerina's performance, but also the entire show. Lively, by contrast, exercised tremendous control over the entire production, as evidence redacted, and not simply over her own performance. It's actually, that's a good point. That's a good point, because she obviously had control over Isabella Ferrer's nudity rider, and despite I'm going to find an interview actually and play it because I think it's really good. I've seen the interview before, but someone else. I'll have to get to it actually. Right. This is a TV and movie addict who posted this clip of an interview with Isabella Ferrer with the cast of Blake Lively. So let's have a look and see what she actually says.
That was the crazy thing, was to talk to you and to be like, I see the through line here. Like, I see where we do have this kind of like core connection with each other. And so also Blake is just the most wonderful, beautiful, amazing person ever. So she was so supportive and gave me as much agency with the role as she gave herself, which was a huge privilege because as a up and coming actor, especially playing younger versions, sometimes it's like the other person's role and then you have to kind of follow in their footsteps. But I was given the opportunity to share my opinion and to voice what I thought, could maybe be added, and that was huge. Yeah, when it came to us acting like each other, I didn't really like practice or anything. I think we just was more very similar. So thank you to casting. That was the crazy thing.
So yeah, that was Isabella Ferrer telling everyone who's listening that it was Blake Lively that gave her agency in her role. Even though Justin Baldoni was the director, Blake gave me as much agency as she gave herself. So, yeah, she definitely had control over other actors, cast and crew. I think she contributed to one of the producers or first assistant directors being fired. A couple of female members of staff being fired, actually. Probably not because they were female, but people highlight it because she is making such a fuss of things happening to her because she's female. So, okay. While the ballerina signed a contract rider that bound her to standard terms, Lively dictated and demanded the unique terms of the CRA. While it remained unclear whether the ballerina was paid as an independent contractor, it is undisputed that Lively received no standard employee benefits, nor was she paid or subject to taxes in the manner of a standard employee. Lively's opposition also points to the ALA, but the terms of that agreement were never fully negotiated and the agreement was never signed. In any event, Lively is relying solely on the language of a pro forma workers' compensation provision, while ignoring the broader circumstances, a particularly myopic approach in an area where courts require a comprehensive multi-factor analysis. The application of California's business-to-business exception similarly cannot be denied, whereas here the work was performed pursuant to a business-to-business transaction between Ainsworth's Movie on the one hand and Lively's loan-out entity Blakell Inc. on the other. The relevant factors set out in California Labor Code 2776A overlap with those of the Reed test or are self-evident from the record, and they uniformly confirmed this was a bona fide business-to-business transaction. 1. Blakell was free from the control of defendants, both under the contract and in fact. 2. Blakell was providing services directly to defendants, not to defendants' customers. 3. The putative contract between the parties was in writing and specifies the payment amount. 4. Blakell had a business tax registration as defendants withheld applicable New Jersey business taxes. 5. Blakell's business location was separate from defendants. 6. Blakell's customary role was to lend out Lively's acting services, the same services involved in the work performed. 7 and 8. Blakell provided the same services to others, advertised herself as available to do so, and then something's redacted, and even insisted upon an alteration of defendant's production schedule to accommodate Blakell's ability to provide Lively's services on another film. 9. Blakell provided the relevant instrumentality for the work, Lively herself. 10. Blakell could and did negotiate its own rates. 11. Blakell could and did demand changes to the location and hours of work. And 12. Blakell was obviously not a member of the construction industry for which a special contractor's license is needed. Because this was a business-to-business relationship, the Borello test, which is materially indistinguishable from the Reed test, determines Lively's independent contractor status under California law, and thus yields the same outcome. Like Reed, Borello examines circumstances holistically, considering, among other things, the right to control, and secondary indicia, like the skill required, who provides the instrumentalities, the duration of the work, and the method of payment. Far from a typical employee, Lively independently contracted through her own private business entity and exercised tremendous control while maintaining the right to work on other projects and for other businesses. If she is not an independent contractor, then there is no such thing as an independent contractor. Lively cannot prove a failure to prevent/investigate claim. Lively knew how to raise concerns, and she did. Thank God they're doing this now. I feel like this is something they have not hammered home hard enough. Lively made herself sound like a vulnerable little wallflower. She is not. Lively knew how to raise concerns, and she did. Heath and Baldoni may have disputed her version of events, but they still acceded to her demands. And although Lively's brief asserts defendants failed to implement any corrective measures, her 56.1 response admits it Enzo's movie agreed to a set of requested protections, through which a redacted set was achieved during all subsequent filming, including all intimate scenes featuring Lively herself. Lively also cannot dispute that, through legal counsel, she declined to pursue formal HR process. Lively tries to rewrite history, claiming an investigation didn't happen because Heath did not want redacted. That claim misleads the court by twisting Alex Sachs's deposition testimony and is not supported by competent evidence. Sachs actually testified that when she first suggested an investigation, redacted. Sachs further testified that she surmised Heath's desire not to have redacted based on her own interpretation, not on anything Heath ever said. Sachs's private speculation about Heath's motives are not admissible evidence, and we also know that Sachs was quite held Heath in contempt for no other reason than he was the lead producer and she was the producer. She wanted to be the one overseeing the film, but Heath was in that position and she was not happy about it, and she admitted that in her deposition. Also fatal to Lively's claim is the lack of evidence suggesting any failure to prevent or investigate harassment was a substantial factor in causing her purported harm. It is undisputed that Wayfarer had appropriate policies and Baldoni and Heath participated in workplace harassment training, because any allegedly harassing conduct ceased once Lively voiced concerns. Any subsequent failure to investigate cannot have contributed to any harm either. Contrary to Lively's argument, there is no causal relationship between the adequacy of defendants' on-set policies or their decision not to conduct a formal investigation and the gravamen of Lively's complaint, a so-called retaliation complaint consisting of social media activity months later. And we have a footnote. Because she is not an employee, Lively cannot bring a claim under Section 12940K at all. Her argument to the contrary. Her opposition cites a different provision of FEHA and ignores the plain language of 12940K itself, which expressly discusses employers, as well as the regulation articulating that provision, which is similarly limited. Lively's contract claims fail. Lively has abandoned her breach claims against Wayfarer. Lively makes no effort to defend her alter ego theory breach of contract claims against Wayfarer, which, unlike It Ends With Us movie, was not a party to the ALA and CRA. The claims against Wayfarer must therefore be dismissed. The ALA is not binding or enforceable against the entity defendants. Lively does not dispute redacted. Lively's arguments to salvage her breach claims in the face of those undisputed facts all fail. Judicial estoppel does not apply. Contrary to Lively's argument, the entity defendants are not judicially estopped from arguing that the ALA is not binding. Judicial estoppel applies only when a clearly inconsistent factual position has been adopted in some way by the court in the earlier proceeding, such that a party would derive an unfair advantage by changing tack. First, the court has never previously adopted any position advanced by defendants with respect to the ALA. In the order of dismissal, it rejected defendants' only arguably related claim. Second, defendants' prior pleading was not inconsistent with their current position. It too pointed out that the ALA had never been signed. It asserted a claim for breach of the covenant of good faith and fair dealing that was never specifically alleged to rest on the ALA. As noted in defendant's opening brief at 41 and below, the parties performed pursuant to a separate offer letter. Third, the entity defendants gained no unfair advantage based on the alleged inconsistency. In dismissing the prior claim, this court noted allegations that the ALA had never been signed, and defendants chose not to replead the claim, though leave was granted. The condition precedent was not waived and no agreement was formed. A. Lively falsely claims defendants confirmed in writing that Wayfarer was waiving execution. That did not happen. The cited evidence shows Heath told Lively's reps, "We have withdrawn our request for your client to sign her agreement in order to extend the time with the edit," i.e., Heath gave Lively more time to edit the film without making signing the draft ALA a condition of the concession. Heath was clear the contract negotiations remained open. He wrote, "As for the future resolution of the contract, we will stand by in hopes that we come to a conclusion soon." Lively also falsely claims Ainsworth's movie did not dispute the execution condition had been waived. The opposite is true. When Lively tried to strike the execution condition and claim it had been redacted, Ainsworth's movie rejected the edit. Lively doesn't dispute that fact, though she labels it misleading, claiming Ainsworth's movie could have more explicitly I'm struggling with this word. Could have more explicitly rejected her assertion of Wayfarer. But Ainsworth's movie was unequivocal that it was not waiving the condition. When Lively later tried to insert the phrase redacted into the draft, Ainsworth's movie again rejected the edit. B. Nor did Ainsworth's movie waive via its conduct. Indeed, Lively's own evidence confirms that because the ALA was not finalized when principal photography commenced, her lawyer insisted that until such time that the long form is fully executed, our client will continue to proceed in reliance upon the terms of the negotiated deal memo. In other words, the parties would rely upon the offer letter. Moreover, both New York and California law require unequivocal expression of intent to waive, especially where, as here, the contract expressly bars modifications not signed and in writing. Lively can't show unequivocal intent to waive here, given her pre-dispute assertion that pending execution of the ALA, the parties would perform under the offer letter. Her repeated unsuccessful attempts to remove the condition from the ALA and Ainsworth's movie's continual request that she sign the agreement. C. For similar reasons, the ALA was never binding. As noted above, Lively does not meaningfully grapple with undisputed evidence showing the parties did not intend to be bound absent a fully executed writing. Instead, Lively merely claims that by July 2nd, 2024, most of the draft ALA's terms were final, and the remainder, she says, were immaterial in practice. It is irrelevant, however, whether many key terms of the ALA were apparently no longer subject to negotiation, because it's a black letter law that if either party communicates an intent not to be bound until he achieves a fully executed document, no amount of negotiation or oral agreement to specific terms will result in the formation of a binding contract. Lively's argument that the ALA was performed also fails because Lively cannot meaningfully dispute that performance occurred under the offer letter, which set forth the key terms between the parties. In any case, performance is only one factor for determining whether an agreement is formed and is not decisive. Lively's argument that execution of the CRA suggests the parties understood the ALA was already a binding agreement is flatly contradicted by the record. It is undisputed that negotiations over numerous provisions of the ALA, including the provision making execution a condition precedent, continued after the CRA was signed, with neither side manifesting an understanding that terms of the ALA were finalized. If the CRA manifested the parties' understanding that the ALA was a done deal, there would have been no need for roughly 6 more months of negotiations, nor any reason for Lively to decline to sign. Even if the ALA was a valid agreement, the execution condition precedent bars Lively from enforcing it. Lively also ignores that even if the ALA were a valid agreement, all defendants are stopped from arguing otherwise, the execution condition precedent would still prevent her from enforcing the ALA as well as the CRA, which was incorporated into the ALA. The draft ALA made execution a non-mutual condition precedent to Ainsworth's movies obligations, not a condition precedent to contract formation. Thus, even if a valid agreement were formed, Lively cannot enforce that agreement because Ainsworth's movies obligations were never triggered. A lot of things were triggered, but not Ainsworth's movies obligations, apparently. The CRA is not binding or enforceable against the entity defendants. 1. Lively's defense of the CRA's enforceability rests almost entirely on her contention that the ALA was binding and enforceable, and therefore fails for the same reasons. Lively suggests the parties would not have bothered to execute the CRA at all unless they intended it to function as an independent agreement, but no such intent is expressly set forth in any writing. Instead, the CRA says the opposite. Indeed, there is an obvious reason why the parties intended to have the CRA incorporated into the ALA. The draft ALA contained an entire agreement provision that refused recognition of any other agreements. If the CRA had not contained words incorporating it into the draft ALA and had not been separately signed, it would have been a nullity. Had the ALA ever been finalized? Okay. 2. Lively's observation that contract modifications do not require new consideration is beside the point, because defendant's consideration argument only goes to whether the CRA is enforceable as an independent agreement. Lively says the CRA was supported by consideration because her obligation to continue filming was doubtful insofar as she possessed a right under the ALA in a provision never subject to dispute to terminate the agreement in the event that sexual harassment took place. That claim is another blatant distortion, however. The sexual harassment provision was edited to permit Lively to terminate only after the CRA was signed. At the time the CRA was signed, Lively had no such right to terminate. Her obligation to perform was required under the offer letter, as she concedes. Lively's claim that there was consideration because she agreed to forbear a claim is also wrong. As she admits, the CRA contained no such promise, and Lively's attorney had in fact reserved all legal rights to bring a claim. Lively's contract claims fail even if the ALA and/or CRA are enforceable. 1. Lively did not provide requisite notice. Lively does not dispute that she did not satisfy the notice and cure provision in the ALA before suing. She claims defendants waived the notice and cure by failing to include it as an affirmative defense, but courts applying California law have held compliance with contractual notice and cure provisions must be pleaded by the plaintiff and need not be asserted as an affirmative defense. The sole case Lively cites for the proposition that failure to comply with the notice provision is an affirmative defense applied New York law. That decision also turned on the specific language of the provision at issue, which made notice a condition precedent to suit, unlike the notice provision in the ALA, which states that no act or omission of Ainsworth's movie shall constitute an event of default or breach absent notice and an opportunity to cure. Lively's contention that she satisfied the provision by amending outside the cure period after her initial complaint provided written notice is absurd. A party cannot evade a clear notice and cure requirements by simply filing a lawsuit and then amending once the cure period has run. The purpose of giving notice of breach would be completely undermined if it could be satisfied with the giving of post-suit notice. Yeah. 2. Lively's damages are barred. Lively does not dispute that she can't seek duplicative recovery for the same injury by asserting overlapping tort and contract claims. Since her claimed contract damages entirely mirror her alleged tort damages, her contract claims fail. Lively also offers no real response to defendants showing that if the ALA is binding, its limitations on damages provision bars most, if not all, her contract damages, and that her other alleged damages, such as her redacted, are unavailable for breach of contract. Lively does not even attempt to defend and therefore abandons all contractual damage claims other than those for the breach of the CRA's anti-retaliation provision. As to the alleged breach of the CRA, Lively argues in conclusory fashion that her alleged injury constitutes general damages. But the case she cites for that proposition, Louis George Construction Management against Pomona Unified, hurts rather than helps her. Therefore, the California Supreme Court held that profits the plaintiff might have earned from unrelated future contracts are not general damages and were too remote to be available as special damages, even though, unlike here, there was no specific contractual special damages waiver, and the industry at issue, construction, was far more predictable than the film industry. Louis George dooms Lively's damages claim. Okay. The defamation and false light claims fail. Lively cannot salvage her defamation claim. Lively concedes, as she must, that her defamation claim is based entirely on defense counsel's denials of Lively's allegations. So these are Friedman's statements, asserted after litigation commenced in the context of discussion of the litigation. That concession is fatal to her claim. Lively cannot establish falsity or malice. Contrary to Lively's assertions, defendants have made a strong showing that no actionable harassment or retaliation occurred as discussed. Accordingly, statements denying Lively's claims are true, or at least substantially true, which is all that is required to defeat a defamation claim. Lively does not meaningfully dispute what constitutes retaliation, harassment, or a smear campaign is imprecise and subjective, such that a denial of such conduct constitutes unactionable opinion. Lively attempts to distinguish Coleman against Grand on the ground that here the alleged defamatory statements imply undisclosed facts and as such are mixed rather than pure opinions. But one can scour the alleged defamatory statements for any suggestion of undisclosed facts. The statements viewed in their entirety rather than via Lively's cherry-picked excerpts repeatedly disclose the basis for the opinions expressed. Okay. Lively also fails to muster evidence sufficient to prove actual malice with convincing clarity, as she concedes is her burden. Lively reiterates her argument that defendants must have acted with malice because they knew that Lively complained of supposed harassment on set. Lively does not respond, however, to the obvious point that knowledge of a complaint is not knowledge that harassment had, in fact, occurred. Lively distorts the record by claiming that Baldoni, Heath, and Saritz admitted Lively genuinely believes her claims, but the cited text message shows Baldoni agreed with Nathan's comment. We also know there was no truth to anything, while merely noting that nonetheless Lively is the kind of person that genuinely believes she's right and that all of this is unjust. That evidence hurts rather than helps Lively's claim. Lively argues for the first time that the statements were false and published with malice because they assert Lively lied about harassment to gain control of the film's marketing appears nowhere in Lively's second amended complaint, and a plaintiff may not, in opposing a motion for summary judgment, rely on theories not set forth in the complaint. In the event, none of the statements specifically says Lively fabricated claims to take over the film's marketing. Lively fails to rebut that the allegedly defamatory statements are absolutely privileged. Lively first suggests the fair report privilege does not apply because an ordinary reader or viewer would not perceive defense counsel's statements as reporting on the proceeding. But a fair reading in the context of the publication as a whole shows the statements were clearly comments on the litigation and mirrored defendant's position throughout the litigation. For example, the article that includes the January 18th statement makes clear the statement was discussing and describing Baldoni's long-expected lawsuit filed days earlier. Similarly, the January 7th statement is part of a video embedded in an article about the ongoing litigation, and the specific statement was commentary on defendant's complaint against the New York Times, plus discussion of documents that only 10 days later would be attached to defendant's complaint against Lively. Lively's argument that the December 21st statement to New York Times did not give readers any way to understand that it referenced Lively's CRD complaint as opposed to the New York Times article itself is even more absurd because the subject matter of the New York Times article and the CRD complaint were essentially the same. In any event, it is not necessary that the court filing, the court, or the jurisdiction be specifically identified in the article for the fair report privilege to apply, and a statement need not produce a court filing or proceed verbatim for the privilege to apply. Comments that essentially summarize or restate the allegations of a pleading filed in an action are the type of statements that fall within the privilege. Moreover, it is beside the point that certain statements were made shortly before defendants filed their claims against Lively, because privilege can apply even before a complaint is formally filed, so long as litigation is anticipated. And Lively's contention that the privilege should not apply because defendants' claims were frivolous fails for reasons described in defendants' opposition to Lively's Rule 11 sanctions motion. Lively has no answer to the First Amendment concerns raised by recognizing a defamation claim based on a lawyer's vigorous denial of allegations against his clients. Her only response is that the allegedly defamatory statements were not general denials and instead suggested Lively would be proven a liar. But it is difficult to imagine any denial that would not at least implicitly convey Lively's claims were false, i.e., that she had lied. Lively also has specifically alleged that the statement that her accusations were categorically false was defamatory. It is difficult to imagine a clearer general denial. First bullet. Okay. Second amended complaint, first bullet, yeah. Permitting Lively's defamation claim to proceed risks chilling attorneys' ability to deny accusations against their clients. and that's incredibly important. Lively's false light claim fails. New York law applies, foreclosing the claim. Lively's choice of law argument assumes the California choice of law provision in the unexecuted ALA applies, but for the reasons explained supra, the ALA is not binding or enforceable. Lively's argument fails in any case because the ALA does not bind the defendants who were never parties to any ALA draft. The general rule is that a contract cannot bind a non-party. And that's important. It's only Enzo's movie who was party to that contract. Everyone else, the individuals, Tag, Jed Wallison Street, Sauritz, Baldoni, Heath, Melissa Nathan, and Jen Abel, they were not parties to the ALA agreement. Lively attempts to run-end this rule by calling these defendants closely related parties of It Ends With Us movie, but her own cases undermine the argument. Loan Care LLC concerned a party that purchased the contracting party's assets and continued its operations after expressly agreeing to perform under the contract, essentially inheriting the contract and its choice of law provision. The facts of this case are not comparable. BTX Communications observed that a non-signatory can embrace a contract's choice of law provision by knowingly seeking and obtaining direct benefits from that contract, and held non-signatories bound in part based on allegations of self-dealing conduct through which the contracts directly benefited the non-signatories. Here, there is no allegation of self-dealing. And then the footnote says, indeed, Lively has abandoned her alter ego-based contract claims against Wayfarer. The only benefits the non-signatories received from the contract were entirely indirect. And in Lipcon, the non-signatories at issue were spouses of signatories to the relevant agreements and sued to enforce rights arising out of the agreements, such that the court concluded their interests were completely derivative. These cases do not support the conclusion that Wayfarer, Baldoni, Heath, and Sauritz must defend a false light claim under California law. And the argument is even weaker still as to Nathan, Tag, and Abel. Lively has not even demonstrated, for example, that any defendant was aware of the clause. Lively separately argues for application of California law, pointing to what she describes as California conduct. Okay. This argument is blind to choice of law principles that favor application of New York law. The overwhelming balance of conduct indisputably occurred in New York or New Jersey, including Lively's pre-filming conversations with Baldoni, Lively's mid-production conversations with defendants about their conduct, defendants' alleged on-the-set behavior, and the premiere of the film attended by Lively and Baldoni. She claims defendant executed a communication strategy from California, but overlooks detailed allegations in her own pleading that placed defendants and herself in New York when that alleged strategy was purportedly hatched. She further ignores that the defamatory statements and media of which she complains emanated primarily from New York, where she resided at all relevant times. In short, the most significant relationship factors clearly support application of New York law. Lively has no standing under California law. Lively would fare no better even if California law applied. Indisputably, a New York resident, she asks the court to ignore the impressive body of authority that limits standing to California residents, relying on no contrary authority. She cites only Doe against Meta Platforms. That case does not confer standing upon a New York plaintiff to bring a false light claim. Far from it, the court noted it was not determining or foreclosing the standing agreement and ultimately dismissed the constitutional invasion of privacy claims as then pled. Lively argues her claims does not depend on the California Constitution and can proceed under the common law. Citing Hill. Lively's second amended complaint, however, pleads a claim only under California constitutional Article 1, Section 1, and not under common law. Moreover, a common law claim would not be actionable based on the mere dissemination of truthful, newsworthy material. And as noted above, Lively fails to identify any dissemination of false information. Okay, Lively's conspiracy claims fails. Lively concedes conspiracy liability cannot arise from contract claims, and she fails to meaningfully oppose defendants' arguments that New York conspiracy liability cannot attach to California FEHA and federal Title VII claims. Her conspiracy claims are entirely duplicative of her underlying tort claims and must be dismissed for that reason alone, let alone that none of her alleged torts can survive summary judgment. Defendant Sarowitz must be dismissed. Lively strains to implicate Sarowitz despite his undisputedly peripheral role. She claims, but without evidence, that he was on set during the birthing scene. Lively's declaration states only that Sarowitz was present on set that day, without specifying any scene or shoot he attended. Multiple scenes were shot the same day. While not disputing that Sarowitz had no contact with the PR firms allegedly responsible for the smear campaign, at least not before this litigation began, Lively claims Sarowitz is nonetheless liable because he made a suggestion about flipping the narrative. She admits, however, that the suggestion merely brought to light the truthful fact that her husband, a male, rewrote portions of the original female script. Lively also fails to identify any evidence to support her claim that Sarowitz threatened to ruin her family. Undisputed evidence shows Sarowitz never made such a threat. Yeah. Lively fails to oppose defendant's damages arguments. Lively's damages arguments confuse the issues. She claims standing to pursue damages to her own reputation, but falsely equates personal reputational harm with the speculative lost profits purportedly sustained by separate businesses. She has no standing to seek such damages, which are in any case too speculative. Cantu only underscores the point. Cantu was personally awarded non-economic damages, not for speculative lost profits, but because the harm to his reputation directly resulted in his inability to secure oil and gas contracts with an identified value. Lively's other cases are inapposite and concern entirely distinct issues, such as standing to sue on a contract or standing to sue corporations based on the corporation's misrepresentations to the plaintiff. Lively cannot dispute that the business entities she redacted. Conclusion: for the foregoing reasons and those stated in the prior briefing, the court should grant summary judgment in the Wayfarer party's favor on Lively's claim. And I knew that was written by Shapiro. That was such a good document. That was such a great document. Fantastic arguments. I don't see how Lively can counter some of these arguments. And as I said at the start, I love the fact that there's kind of humility and honesty to say, look, yeah, there were some minor grievances, right, which are subjective. Like, she is making big issues out of things that are really trivial. Her reaction to them is subjective. Most people, like, Ange Giannetti was shown the Heath birth video, and she did not find it remotely offensive. Lively lost her shit. It's like, these are trivial. They're trivial, but also they're very subjective on how someone perceives them. And there was a lot of highlighting and contrasting of that. Using the deposition transcripts as well to say, well, hold on a minute, Lively's taken Alex Sachs's deposition statements out of context and she's twisting them. And also pointing out, Sachs herself says, well, it's not, they made women and men uncomfortable. Now, had Lively not stupidly put in her Rule 56.1 statement, if she hadn't put that statement from Alex Sachs about women and men being made uncomfortable, it's as it's in the Rule 56.1 document, it's an undisputed fact. So Lively is kind of, if you want, for better words, claimed authorship of it. But she's basically saying, agreeing with what Sachs says, so it's no longer hearsay. She's agreeing with Sachs that it is undisputed. So Lively now has adopted the stance that Wayfarer or Baldoni or Heath made women and some men uncomfortable. And that may be for no other reason than they're just, quite effeminate, touchy-feely, kind of, huggy-huggy, hippy-dippy kind of people, right? Which is absolutely nothing wrong with that at all. That is not for many men for many reasons, right? Look at Ryan Reynolds. It's also not for every woman either. Does not mean it's a bad thing, that it's something that's actionable that requires all of this. But by Blake Lively using that quote from Sachs and putting it in the Rule 56.1, it is no longer hearsay. So whereas, Wayfarer are pointing to Saladino's comments and some of Alex Sachs's comments as general hearsay and opinions, which are not based on evidence or anything that, in that case, Heath said. Lively now has made that statement no longer hearsay. Obviously, it's still Alex Sachs's statement, but Lively has claimed it as an undisputed material fact. And that, I think, is going to cause her a lot of problems now, because the sexual harassment and the discrimination has to be on gender. And she has claimed, that things are being done because of her gender, when clearly now she's contradicting herself and citing people, citing statements from people who were on set, which also contradicts her original position. So, all right, I'm going to wrap up there, and I will be back with the Jones Works response from Jen Abel.